So welcome to today's webinar on children and entry clearance with Adam Pipe from number 8 Chambers. For those of you who haven't joined our webinars before, my name is Lucy and I'm a consultant at DG Legal. I'll just go through a little bit of housekeeping today before we begin. So the slides from today's presentation will be sent over to all delegates tomorrow, and a recording of the webinar will be available for 3 months. So if we do run over and you do need to leave, you will be able to watch the rest at another time. We are in webinar mode, so we can't see or hear any of you. So please do use the chat and Q&A function to participate in the webinar. And if we have time at the end, Adam will address any questions you might have. I will caveat that with if we do have time, as we may not today. But by way of a brief introduction to our speaker, Adam Pipe is a barrister specialising in immigration, asylum and human rights law, and is ranked by Chambers and Partners for immigration law in the Midlands. Adam provides regular updates on the law at training events and on social media. Thank you very much, Adam. Over to you.
Brilliant. Thank you, Lucy. And really great to see, or not see everybody, to have everybody here on the webinar today. Today, I'm covering children and entry clearance, and we're going to be looking at 3 main sections. We're going to be looking at sole responsibility. We're going to be looking at serious and compelling, and we'll finish by touching upon Article 8. As Lucy said, you'll be sent a copy of the recording and a copy of the slides after this webinar. And hopefully you'll be able to utilize my slides in your representations, in your appeal skeleton arguments, and under the new appeal systems. The appeal skeleton argument is such a key document, and in relation to any grounds of appeal for onward appeals you're drafting. So you'll be able to use the quotes and the bits in my slides, and hopefully that'll be helpful to you. As Lucy said, my name is Adam Pipe. I'm a barrister based in Birmingham, although I appear in the Immigration Tribunal throughout the country. And can I just say, I think at last count, there were about 850 people registered for the webinar today. So if you're watching live, thank you. And if you're watching the recording, thank you so much. And one thing I'd encourage you to do is, if you've got a team of lawyers working with you, if you work in a practice, you may want to use the recording of this presentation for some ongoing CPD training, and you'll be able to pause and discuss as you go. I'm going to pose some questions as we go. Do feel free to put the answers to those questions in the chat. If you've got any technical issues, pop them in the chat too. If you've got any specific questions, put those in the Q&A box. And if there's time, and I'm not promising there'll be time, but if there's time at the end, I'll try and get to some of those. But often in these webinars, I'm trying to cram as much as I can into 1 hour. What I've put up on your screen now, and this is the one time I encourage people in my seminars to get their phones out. Do get your phone out and scan the QR code that is on my slides. And don't worry, I'm going to put it back up on the final slide today, or you can use the link on the slide when you get the slide sent through to you. That will give you some links to some of my free resources and immigration law updates. So you'll be able to access there some recent DG Legal webinars I've done. So I've left the recordings on my YouTube of the private life webinar I've done, the visit visa webinar, and the key immigration law case law update from 2022. So all the key cases of 2022, they're available there for you. I also provide a Telegram channel which provides regular immigration law updates. So I'd encourage you to subscribe to the Telegram channel. It's all free. Subscribe to my YouTube channel, where you'll be able to get access to regular immigration law update videos. There's also on those links some free PDF case law updates I've done, and links to webinars and upcoming seminars that I'm presenting. So I hope that's helpful to you. Let me pose a typical scenario and feel free to type your answers in the chat. So if you're an immigration representative, a Jamaican woman with indefinite leave to remain under the legacy, so it was a legacy grant, comes into your office tomorrow. She wants to apply for entry clearance for her 16-year-old daughter. Her daughter lives with her maternal aunt, that's mum's sister in Jamaica. Father is thought to be somewhere in Jamaica, but is not in contact with the child. The sponsor came to the United Kingdom when her daughter was 2 years old and lives with her partner and British children here. What rule or rules are you going to apply under? So you're advising this client, what rule or rules are you going to apply under? Start to type it in the chat. And what sort of evidence would you be looking for? What are you going to say in your application and your representations about Article 8 and Section 55? If you've got an answer to any of those, what rules you'd apply under, what evidence you'd be asking the client to provide you, or what you're going to say about Article 8, do type that in the chat. I can already see some answers coming in the chat. People are talking about 297, sole responsibility. They want evidence of education and health. Somebody's talking about Part 8 of the immigration rules. Evidence for sole responsibility. It'd be interesting to think about what we mean. Somebody's referred to Appendix FM. We'll have a look at that. Somebody in terms of evidence of financial and emotional. That's an interesting, we'll cover that today. Somebody's talked about best interests of the child. We'll definitely come to that today. Somebody's put, show that mother has made all the decisions about her life, her education, etc. If you type that in the chat, you get a gold star straight away. Lots of brilliant answers in the chat. So have a look at those in the chat. And maybe if you're watching the recording with some people from your office, stop at this point and have a chat amongst yourselves in terms of good practice, how you would be advising a client, what evidence you'd be looking for, what you'd want to say in your representations. I should have said earlier, today is the first webinar I'm presenting with my new standing desk, so I can get very Welsh and passionate today and excited about the webinar. If you want to know what standing desk I'm using, do hit me up sometime and I'll let you know. Although if I collapse halfway through this webinar, I'll try and get the desk back up. So here we go. Let's have a look at the key immigration rule. And the one we're going to spend most time looking at today is Rule 297. So it's indefinite leave to enter as the child of a parent, parents, or relative present and settled, or being admitted for settlement in the United Kingdom. And we can see that Roman 1 is broken down into a number of subsections. And the key ones we're looking at today are the ones in bold. It's E and F. And I think a lot of people in the chat, when I just asked that question, referred to E. One parent is present and settled in the United Kingdom or being admitted on the same occasion for settlement and has had sole responsibility for the child's upbringing. So we're going to look at, in the first section of this webinar, what is the meaning of sole responsibility? And already some of the answers in the chat have started to tease that out. Notice in E that a sponsor has to be a parent. If you're not a parent, but you're a relative, you're going to have to use 1F. One parent or a relative is present and settled in the United Kingdom or being admitted on the same occasion for settlement, and there are serious and compelling family or other considerations which make the exclusion of the child undesirable and suitable arrangements have been made for the child's care. That's what we're going to look at in the second part of the webinar, this what is serious and compelling family or other considerations. But notice a relative can use this. Although don't forget to check through A to D. Don't just jump straight to E and F, because I've certainly had a case sent to me to present on the basis of sole responsibility or serious and compelling, where it turns out that one of the parents has actually died. And I've had to say at the appeal stage, well, actually, we can satisfy 1D and we don't need to meet the sole responsibility rule. Now, we're not going to spend time today looking at some of the other Roman numeral requirements. So leading an independent life, not leading an independent life, accommodation and maintenance, but do note its adequacy. It's not the Appendix FM test, 18,600, it's adequacy of maintenance under 297. We're going to focus on E and F, but remember when you're checking with the client, so I said that dad had disappeared, not in touch in Jamaica, well, check he's still alive because you may meet 1D. Somebody mentioned in the chat Appendix FM. So if the sponsor has limited leave as a parent or a partner, they will be able to apply for their child under Appendix FM. And I've put on the slide ECC 1.6, and you'll see B and C there mirror the requirements, has had and continues to have sole responsibility, and there are serious and compelling family or other considerations which make exclusion of the child undesirable. And notice there, one of the applicant's parents must have been in the UK with limited leave to enter or remain, or being granted or have been granted entry clearance as a partner or parent under this appendix. So they've got to have leave under that appendix. Just before we leave the immigration rules, I wanted to touch on the exceptional circumstances provisions in Appendix FM. Because if you are applying under Appendix FM, in your representations, it's also worth addressing Gen 3.2 and Gen 3.3. So Gen 3.2 applies to all of Appendix FM, where you can't meet the requirements of Appendix FM, or another part of Part 9 of the immigration rules. They've got to consider then Article 8 and whether the decision, a refusal, would result in unjustifiably harsh consequences. And whilst they refer to exceptional circumstances, this is an Article 8 proportionality assessment. And you'll notice, actually, just as a bit of a side, when you see some of the new appendices to the immigration rules, say the new family reunion appendix, that has within it an Article 8 exception. So the way the rules are now being written will often contain an Article 8 exception. And Gen 3.3 now provides that the best interests of children must be considered by entry clearance officers when applying under Appendix FM, and it applies to any relevant child. So look at Gen 3.32b, a relevant child, it is evident from the information provided by the applicant would be affected by a decision to refuse the application. So I said in my example that mum was living in the United Kingdom with her British children. So it's not just the best interest of the applicant you want to be referring to in your application, but also the best interest of any children here that the sponsors had, perhaps as a result of a new relationship in the United Kingdom. And can I just pause there? Actually, one of the things that's worth looking at and getting evidence is you'll often find that the children of the sponsor in the United Kingdom have a close relationship with their half sibling, the applicant. And getting statements from the British children in the United Kingdom, if they're old enough, is something that's worth thinking about. And I think to give some extra meat on the bones in terms of an Article 8 consideration, that's worth doing, and looking at all the children who may be impacted by the decision. So let's look at the first issue today, and that's sole responsibility. I'm going to give you some key guidance and case law. So again, let's check you haven't fallen asleep at lunchtime. How would you define sole responsibility? Start to type in the chat now. Some people already started to hint at this. What evidence would you want to demonstrate sole responsibility? Anybody who wants to pop in the chat any evidence. So somebody's just popped financial, all the main decisions, making decisions, financial dependency. Sponsor plays main role, financial, medical, educational, letters from school, doctors, the aunt, good answer, that one. Sponsor parent takes the key decisions such as education. I think that's really helpful. Birth certificate, yeah, that's important. Affidavits, letters from school, custody order. Now, we're going to come to that definitely, because court orders. Just have a think while I'm on here. Would anybody want to get a statement from the absent father? Anybody want to get a statement from the absent father saying that he has no objection? Somebody says yes, if possible. No, somebody says no. Good. I'm glad there's a bit of an argument. It can be a two-edged sword, exactly, because I think there's a real issue with this. And I don't know if it was in previous guidance that somebody should get a statement from father. But if you're saying you're the one who makes the key decisions in the child's life, why would you need something from the absent parent? And often you'll see a refusal from an entry clearance officer suggesting that dad is perhaps involved in the child's life, and this is a manufactured situation. Now, recently, we had to get an affidavit from a child's absent mother in Cameroon in order to get a passport for the child to make the application. And straight away, the entry clearance officer refuses on that ground. And as part of the appeal, which we were successful on, we had to get evidence showing that we needed that in order, and it was a legal requirement to get the passport. But generally, my feeling is in this scenario where you've got an absent parent, no statement from them. So let's define sole responsibility. This is a quote from MacDonald's Immigration Law and Practice, and I thought it was a helpful summary. The phrase sole responsibility is intended to reflect a situation where the primary parental responsibility for the child's upbringing rests with one parent. The parent claiming sole responsibility must satisfactorily demonstrate, that's where your evidence is going to come in, that they have been the person exercising primary decision-making concerning the child's upbringing. So that's the phraseology you want to put in your representations. Sole responsibility is a factual matter to be decided on all the evidence, where one parent is not involved in the child's upbringing because he or she has not assumed any responsibility for the child. The issue may arise between the remaining parent and others who have day-to-day care of the child abroad. So we don't have to just show dad's not involved. In our scenario, we'd have to show, well, aunt's got day-to-day care, but she's not exercising continued control and direction. And that's the test. The test is whether the parent has continuing control and direction over the child's upbringing, including making all the important decisions in the child's life. Where both parents are involved in a child's upbringing, the assessment of sole responsibility is more difficult. I think that's a slight understatement, but we're going to look at that. There may be cases where you can win and both parents are involved, but I think they're going to be rare. So let's look at some guidance. This is some Home Office guidance, and this is the family life as a parent or partner in exceptional circumstances. And this is the current version 19 from the 18th of May this year. Any highlighting in my slides is my highlighting. It's something I've added. Sole responsibility for the purpose of the immigration rules must be interpreted as set out in this guidance. Well, that's for the Home Office. Remember, guidance doesn't bind the court. The court, as we know from the Supreme Court in Mahad, looks at the plain, sensible meaning of the immigration rules. Sole responsibility means that one parent has abdicated or abandoned parental responsibility, and the remaining parent is exercising sole control in setting and providing the day-to-day direction for the child's welfare. In assessing whether the applicant has sole responsibility for a child, you must consider if evidence has been provided to show that decisions have been taken and actions performed in relation to the upbringing of the child under the sole direction of the applicant, without the input of the other parent or any other person. The applicant parent is responsible for the child's welfare and for what happens to them in key areas of the child's life, and that others do not share this responsibility for the child. Now, I think the age of the child is relevant here, because in our example that we'll have in the background, I said the child was 16. How decisions may be made with a 16-year-old, often where the sponsor will be, say, WhatsApping them, and the applicant says, "Mum, I want my ears pierced," or I want to go on a school trip, or I want a new mobile phone. That will be the communication, and then perhaps they'll inform the sponsor. So those sort of chats and that sort of information you might want to exhibit in your application, whereas it may be very different in the case of, say, a 4-year-old child, where it'll be the sponsor and the aunt, say, on the ground communicating directly. Look at the third bullet point. The applicant parent has exclusive responsibility for making decisions regarding the child's education, health, medical treatment, religion, residence, holidays, and recreation. So if you're giving a client a sort of checklist, or if you've got a sort of client care letter that you want to, for this type of case, you want to tell a client what sort of evidence they gather, evidence from the school that shows the sponsor is the one taking responsibility and how they communicate with the sponsor. I always find in appeals, the presenting officers will always cross-examine and say, who goes to the parents' evening? How do you get the school reports? So it's a big thing for the Home Office. Health, perhaps letter from doctors, any clinics. In the statements, refer to any health emergencies or issues of medical treatment. Religion, if mum has arranged for the applicant to go to church, to mosque, to temple, that's something that needs to be referred to. In terms of arranging residence, holiday, recreation, again, that's something that can be set out both in the statements. And of course, I've already hinted at this. We want a statement from the sponsor, a statement from aunt on the ground, a statement perhaps from the, in a 16-year-old case, I think a statement from the applicant, certainly. Protecting the child and providing them with appropriate direction and guidance. Give examples of where you've had to give direction and guidance. I had a lovely case the other day where the father in the United Kingdom said, my daughter had a phone, but she was misusing it and her schoolwork was suffering. So I've now taken the phone off her and she has to communicate on the aunt's phone who's looking after her. And I said to the judge, well, that's a lovely nuanced example of where dad has made a decision and that actually had to change a decision to take the phone back because it wasn't being used well, and shows that dad is taking control and direction of that child's life, so that the child's property. In addition, you should note that sole responsibility is not the same as legal custody. So in the chat, I think a few people popped in about getting a court order or a custody order. Now that is relevant evidence, but it doesn't mean you just win automatically. Sole responsibility is a factual consideration. And sometimes I do see, how can I put it, dodgy court orders that suddenly appear. And sometimes I think they do more harm than good. If there is a court order, yes, exhibit it. But it doesn't mean that that obviates the need to collect this evidence and give examples of the factual situation showing sole responsibility. Significant or even exclusive financial provision for a child does not in itself demonstrate sole responsibility. Now, financial provision is important, and showing that you provide it is key, but it's not all or nothing again. It's not like the court orders, it didn't just win or lose you the case. It's something that you need to show, but it's one of all of a factor of circumstances. And interestingly, the other day, I think it was my Cameroonian case, she was living with the sponsor's brother, her paternal uncle, and it said in the application, well, he partly provides for me. Now, what he was doing effectively is buying some groceries and feeding. And the entry clearance officer refused it, saying, oh, well, you haven't shown that the sponsor has significant financial responsibility for you. And again, the judge rejected that approach, but certainly set out the financial provision. Where both parents are involved in the child's upbringing, it'll be rare for one parent to establish sole responsibility. Now, this is interesting. I'm going to come to this with an old case in a bit. Sole responsibility can be recent or long-standing. So perhaps if there's been a death or a departure, there may be a recent change in responsibility, but flag up at that point, that's something you're going to need to evidence very carefully. Because say you've got a child who's approaching 18, say they're 17, I chose 16 as an example, but let's change it slightly, and they're 17. They've been living with mum in Jamaica, and just before they turn 18, they make an application for entry clearance because dad has now either abandoned them or is off to Canada. Yes, there could be a recent change in sole responsibility, but expect that to be scrutinized to see whether it's genuine and not an attempt to circumvent immigration rules. Just carry on in the policy now. It is unrealistic for a child to have contact with no other adult other than the parent exercising sole responsibility. We accept that the child will have contact with other adults, including relatives, and these are likely to include some element of care towards the child, either generally or specifically, such as taking the child to school. So it's aunt in this case, isn't it? Actions of this kind that include looking after the child's welfare may be shared with others who are not parents, for example, relatives or friends who are available in the practical sense, providing the applicant, that should be sponsor, read sponsor for that, has overall responsibility on their own for the welfare of the child, because you're not considering whether the applicant or anyone else has day-to-day responsibility for the child, but whether the applicant has continuing sole control and direction of the child's upbringing, including making all the important decisions in the child's life. What I've also put in the slides for you is the old Immigration Directorate instructions, because they're still on the Home Office website, and they do provide some helpful stuff that you can lift out into your applications. Look at some of the stuff in them is a bit weird and a bit out of date, but have a look at 4.1. A parent claiming to have had sole responsibility for a child must satisfactorily demonstrate that he has, usually for a substantial period, now we've already talked, that could be for a short period, but usually a substantial period of time, been the chief person exercising parental responsibility. For an exclusion to be accepted, it must be shown he has and still has the ultimate responsibility for the major decisions relating to the child's upbringing and provides the child with the majority of the financial and emotional support he requires. Look at 4.2. Now, this bit I've highlighted, I always put in my appeal skeleton arguments. Where the child and parent are separated, the physical day-to-day care of the child must be entrusted to others. And it is expected that the way the child is being looked after by relatives, they should be the relatives of the parent claiming sole responsibility, rather than those of the other parent. Should this be the case, the parent claiming sole responsibility must still be able to show that he has retained the ultimate responsibility for the child's upbringing and provides the majority of the emotional and financial support needed. So in our case, we're all good because she's living with mother's sister. If she was living with dad's sister and we were saying dad's off the scene, that may raise some suspicion. Now, just because, again, she's living with mum's sister doesn't mean we win automatically, and we've still got to show that control and direction and the overall emotional financial support provided by the sponsor. But you would always expect the sponsor to have arranged somebody to look after their child. Let's have a look at the factors that might be considered. And I just wanted to point something out from the first sentence. There may be cases where, say, dad has some contact, look at the end of the first line, that is so small a share that it can effectively be disregarded. So say dad popped in and gave her a present once a year on her birthday, or maybe birthday and Christmas. I think you could still argue that that's such a small share that can be disregarded, and that doesn't show dad having any control and direction over the child's life. But if you go down and look at the bullets, I think these are some issues that need to be addressed. The period for which the parent in the United Kingdom has been separated from the child. So we might have an issue in our case because mum left her when she was 4. She's now 16. Why hasn't mum applied earlier for her? Now we might want to show, well, mum's a legacy grant. So mum didn't get granted for a significant period of time. So she couldn't apply before that time. I also said, well, mum was having British children. So while she was having her British children, maybe she was unable to sponsor her daughter because she wasn't perhaps working and she wasn't in a position to offer maintenance and accommodation. Make sure you address the second bullet point, what arrangements were for the care of the child before the parent migrated, to show, well, when mum was back in Jamaica, she was living with the child and she had that key responsibility at that time. Who's been entrusted with day-to-day care and control of the child since the sponsoring parent migrated here? So the arrangements, which relatives she's gone to during that point. Who provides and in what proportion the financial support for the child's care and upbringing? And there may have been a period where mum couldn't provide finances because she wasn't allowed to work. And so the period from when, but so as soon as she got ILR, then she started remitting money and taking over financial responsibility. Who takes the important decisions about the child's upbringing in terms of with and whom they live, choice of school, religious practice, degree of contact. So did mum visit Jamaica as soon as she got ILR? Has there been regular visits? If not, why not? What part in the child's care and upbringing is played by the parent not in the United Kingdom and his relatives? So dad not involved, no involvement from that side of the family. The key tribunal case is the case of TD Yemen. So this is something you're always going to want to refer to in your representations and in your skeleton arguments. It's a case from 2006 from Professor Grubb. And the head note reads like this: sole responsibility is a factual matter to be decided upon all the evidence, where one parent is not involved in the child's upbringing because he or she has abandoned or abdicated responsibility. The issue may arise between the remaining parent and others who have day-to-day care of the child abroad. The test is whether the parent has continuing control and direction over the child's upbringing. You can see that in McDonald's, they've effectively lifted the definition from this head note, including making all the important decisions in the child's life. However, where both parents are involved in a child's upbringing, it will be exceptional that one of them will have sole responsibility. Now watch that. The Court of Appeal has commented on that because that's not a legal test. It's more just an expectation. Let's give you a couple of paragraphs from TD Yemen. So in reaching a decision on what is a fact-rich issue, it is important to take into account of evidence of any contact between the parent and the carer in respect of important decisions to be taken about the child and its upbringing. So again, say the WhatsApp chat between mum and her sister, detailing what happens in terms of school, O-level choices, those kind of things. The availability of modern communications technology may reduce the impact of distance alone on a UK parent's ability to be consulted and therefore decide about the child's upbringing in another country. The length and cause of the separation of the parent and the child and the reasons for its continuation may shed some light on the role played by the carer abroad. So again, that's why I flagged up in that example. She left when the child was 4, the child's now 16. What's happened during those 12 years needs to be engaged with. Likewise, it may be helpful to look at the financial support provided by the parent, and in particular, its absence may be very telling. And there's a great summary paragraph at paragraph 52. There are, I think, 9 Roman numerals, and it's worth addressing each of them in turn in your representations as far as they're relevant. So who has responsibility? It's a factual matter to be decided upon all the evidence. So you'd be saying, as a matter of fact, for these reasons, mum has responsibility. It's not about it. Look at Roman 2. It's not about a theoretical or legal obligation. So that's why I say just having a court order from another country is not going to automatically win the case, but rather it's a practical one in which each case looks to who is in fact exercising responsibility for the child. That responsibility may have been for a short duration, in that the present arrangements may have begun quite recently. So if that's the case, address that head on. Responsibility for a child's upbringing may be undertaken by individuals other than the child's parents, and we've already talked about you'd expect it to be the relatives of the sponsor, and may be shared between different individuals, which may particularly arise where the child remains in its own country whilst the only parent involved in its life travels to and lives in the UK. So that's our scenario here. Wherever the parents are, if both parents are involved in the upbringing of the child, it would be exceptional. And again, just caveat that, we'll come back to that in a second, that one of them will have sole responsibility. If it is said that both are not involved in the child's upbringing, one of the indicators for that will be that the other has abandoned or abdicated his responsibility. In such cases, it may be justified to find that the parent no longer has responsibility for the child. However, the issue of sole responsibility is not just a matter between the parents. So even if there's only one parent involved in the child's upbringing, that parent may not have sole responsibility. In the circumstances likely to arise, day-to-day responsibility or decision-making for the child's welfare may necessarily be shared with others, such as relatives or friends, because of the geographical separation between the parent and the child. That, however, does not prevent the parent having sole responsibility within the meaning of the rules. The test is not whether anyone else has day-to-day responsibility. So it's not about cornflakes or Rice Krispies for breakfast, but whether the parent has continuing control and direction of the child's upbringing, including making all the important decisions in the child's life. If not, responsibility is shared and so not sole. I just wanted to give you a couple of other cases you might not be familiar with, which will help you in certain issues. So we've talked a bit about what happens where circumstances change in a short period of time. At the top of this slide, I've put the summary of this case from Butterworth's Immigration Law Service. The case of Maju and the entry clearance officer from 2000. And it says this: the Court of Appeal held that previous cases were wrong to require a minimum period for the exercise of sole responsibility, such as a not inconsiderable period of time. In the instant case, when the relative who'd been caring for the child overseas died, the sponsor assumed sole responsibility. The few weeks for which this was exercised before an application was made for entry clearance were long enough to meet the requirements of 2971E. Now, if one of the parents has passed away, don't forget we have got that other provision I referred to earlier. But at this time in 2000, the court were considering the scenario where somebody had died, one parent had died, and they were looking at the question of sole responsibility. And they said, paragraph 23, time cannot on its own be a conclusive factor. Consider a child of separated parents who agreed on separating that the mother abroad should have sole responsibility for the child's upbringing during her life. But if the mother became incapacitated or died, then the father in the United Kingdom would take over sole responsibility. Assume mother, as a result of an incident, becomes mentally incapacitated, and there is no local carer interested in assuming responsibility beyond telephoning father to inform him of the situation. Assume father immediately takes sole responsibility and thereafter takes steps to apply for entry clearance for the child and pays for its fare. It seems to me that this case clearly falls within the subparagraph, even if the entry clearance officer is faced with taking a decision within days of the advent of the mother's incapacity. Now, that doesn't mean time is irrelevant. Paragraph 24, I accept that time may often be a relevant factor when deciding whether the facts as found lead to the conclusion that the United Kingdom parent was exercising sole responsibility for the child's upbringing. So they give another example. Consider the child of separated parents whose mother abroad has been looking after him for some years with no interest shown by the father. Mother suddenly becomes incapacitated when the child is nearly 18, and father, on hearing this over the telephone, sends enough money to a local carer to pay for care for a few months. And an application is made by or on behalf of the child for entry clearance. Certainly in the absence of any prospect of future education, it might well be found that the father has never assumed sole responsibility for the upbringing of the child, but was merely reacting mercifully in an emergency. So that's a child that was nearly 18. Remember, age, that they're going to scrutinize it very carefully. If, on the other hand, mother had become incapacitated when the child was 12 and the father made arrangements at his sole expense for the next 6 years, then it would be easier to come to the conclusion that he had assumed sole responsibility for the upbringing of the child. So again, it's not a question, paragraph 24, can 2 months be substantial? It's a factual assessment. But in this case, they accepted that sole responsibility had been established. What about a case where 2 parents are involved in the child's care? And remember, I said in TD, they talked about it would be exceptional. And I said the Court of Appeal had something to say about that. Well, Bydov from 2012 is that case. Interestingly, and I've set it out in the slides just to help you, I'm not going to go through it, but it gives you some quotes from some older Court of Appeal cases. The quote from Ramos deals with day-to-day care. Again, it quotes from Maju, which we've just looked at in terms of the difference between legal responsibility and responsibility in fact. And then it also looks at the case of Sene. So helpful, some old cases. They then refer to T.D. Yemen. And they quote that bit I quoted to you, wherever the parents are, if both parents are involved in the upbringing of the child, it will be exceptional that one of them will have sole responsibility. But what the Court of Appeals say is the IAT clearly did not mean to impose a legal test. Its review of the cases is predicated on the fundamental proposition that the issue of sole responsibility is one of fact. It was doing no more than identifying where the necessary factual inquiry is likely in most 2-parent cases to lead, and such a proposition is accurate. And they give some examples. So Pusey, the sponsoring parent in the UK was father, and the child had lived for 12 years with grandmother and mother in the country of origin. Although father shouldered the main responsibility, the close contact of mother meant that there was not sole responsibility in that case. But then look at the other side, and that's why I've highlighted it, because you may have a rare 2-parent case where there's still responsibility. And Alagon and the entry clearance officer Manila from 1993 might be helpful. The parent remaining in the country of origin occupied the same house as the child, which belonged to the sponsoring mother, and he was divorced from her, made no contribution and took no part in the child's life. So mother here, child in her house, dad's divorced, but he's still living in the property in Manila, and mother was held to have sole responsibility. And they say in the Court of Appeal that illustrates the factual nature of the inquiry and the proposition that even where there is a second parent in close physical proximity to the child, she or he may not be taking any responsibility for him, but it's still going to be a very rare case. DN is a Scottish case. When I looked on Bailey, actually, for some reason, the judgment wasn't there. The citation was there, but the judgment wasn't there in full. So what I've done, I've extracted the summary from McDonald's. And again, it's something helpful to put in your representations in terms of those who provide day-to-day responsibility. And just because there's day-to-day responsibility in DN, they give an example of those responsible for a child at boarding school and those who provide accommodation for the child during the holidays. And that doesn't necessarily mean the sponsoring parent does not have sole responsibility. So again, something useful that you might be able to use in your representations. Let's close out this first section. And I appreciate I've spent the longest time on this and time is rushing. We may not get to questions. Let's look for a quote from Free Movement. And I think this is helpful. It is the concept of authority or control over a child's upbringing, which is important. While others, for example, relatives may look after a child, it may be that they're doing so on behalf of the child's parent. And that's what we want to show. A really key issue will be the evidence of contact between the applicant parent and the carer on the important decisions to be taken about the child and his or her upbringing. In situations where only one parent is in the picture, if that parent can show that he or she has control of the major decisions that affect a child's life, even from afar, then this will be strong evidence to suggest that they meet the sole responsibility test. The court suggests it may also be helpful to look at the financial support or lack of it provided by the parent to the child or the carers of the child for purpose of his or her upbringing. The court specifically mentioned that its absence may be telling. So this issue should be highlighted, either confirming financial support is given and providing evidence of this, or explaining that it is not and explaining why not. So that's a helpful encapsulation of all that we've done. Let's quickly have a look at the second section and then we'll finish on Article 8. So serious and compelling. Again, just to check you haven't gone to sleep or into a food coma at lunchtime when we're recording this, just type in the chat how you would define serious and compelling circumstances and what evidence you'd want to have for serious and compelling circumstances. Anybody want to type in the chat what you think in terms of what is serious and compelling circumstances and what evidence you'd want to ask for in social work report? Now that's really interesting. Health medical expert reports such as from a social worker. Yeah, I think now in a Zoom work, medical reports, harm to the child, police reports, local authority, that's brilliant. So, now somebody said about earthquakes, child living on the street. So where there's been natural disasters, that could be something, mental illness and physical illness, the living condition of the child. What I was going to say, in a sort of Zoom world, there may be cases now where we could get a social worker in the United Kingdom. And I don't know if any of the social workers who regularly, I know there's a number of social workers who regularly attend my webinars. If anybody's online today, be interesting to know if you've done any of these, where the social worker in the UK perhaps interviews the applicant child and perhaps whoever they're living with over Zoom or Teams, and perhaps does an interview. Yes, we have. Thank you. A social worker is on. I won't name them, but if you need a recommendation, I'm happy to provide their details to you if you come to me. They've done that. So in these type of cases, so social work or health reports, getting good quality medical evidence from abroad. Also such an issue in adult dependent relative cases, good quality medical evidence. And sometimes I think there's a lot to be said for getting evidence from the UK, perhaps using an interview, even getting a psychologist or a psychiatrist, especially if they speak the language, or if not, make sure you get a proper interpreter. Don't have the family interpreting, because then that will depreciate the value of it. So here's the old Immigration Directorate instructions. The objective of this provision is to allow a child to join a parent or relative in this country only where that child could not adequately be cared for by his parents or relatives in his own country. I hadn't thought about it until earlier when I was rereading my slides that you might argue 1F, where the relative is sponsoring, but the parents are still there in the home country. Say the parents are drug addicts, and you can show that, and they've abandoned the child. That's where parents may be on the scene, but you'll still be able to argue 1F. The guidance is a bit strange. It goes into different, when they'll consider the circumstances of the child and when they'll consider the circumstances of the family. I think post sort of best interests, I think it's a broad global consideration, but I've put the old Immigration Directorate instructions on my slides. It's worth having a look at those. But the key case I wanted to get to is Mundiba. Mundiba doesn't just give us guidance on the serious and compelling family or other circumstances. It also gives guidance on the role of Article 8 best interest, which we're going to come to in the final section of the webinar, in entry clearance cases. But I'll go through the head note now. The exercise of the duty of the entry clearance officer to assess an application under the immigration rules as to whether there are family or other considerations making the child's exclusion undesirable inevitably involves an assessment of what the child's welfare and best interests require. So in a modern interpretation of the rules, it's going to involve the child's welfare and best interest. So make sure you're citing that. And again, Mr. Justice Blake here makes reference to Article 3 on the UN Convention of the Rights of the Child and saying about any action concerning children undertaken by administrative authorities. And again, he refers to the IDI saying that the statutory guidance issued under Section 55 must be considered, and I'll come to that in a moment. But here's the key part highlighted. So if you're doing a serious and compelling argument, this is what you're going to argue. Family considerations require an evaluation of the child's welfare, including emotional needs. Other considerations come into play where there are other aspects of a child's life that are serious and compelling. For example, where an applicant is living in unacceptable social and economic environment. And thank you for those who put in the chat about country evidence, maybe country expert reports, looking at where there's been real disasters and stuff in the country. The focus needs to be on the circumstances of the child in the light of his or her age, social backgrounds and developmental history, and will involve an inquiry as to whether there's evidence of neglect and abuse. I've certainly had somebody in South Africa who had suffered a lot of domestic violence as a child. We had her see a psychologist and we relied upon that in the case. There are unmet needs that should be catered for. As a child, perhaps there's specific needs. In our example, it was a daughter, a teenage daughter. Does a teenage daughter have specific unmet needs that are not being catered for? Are there stable arrangements for the child's physical care? The assessment involves consideration as to whether the combination of circumstances are sufficiently serious and compelling to require admission. So you're going to say, look, the global circumstances mean that there are compelling circumstances which require admission. And look at Roman 5. I use this in all my cases involving children and entry clearance as a starting point. The best interests of a child are usually best served by being with both or at least one of their parents. Interestingly, actually, they also refer there to continuity of residence is another factor. So the tribunal will consider continuity of residence. How's the child going to be affected by a change in their residence? That's something worth considering. So what I've done in the slides is set out the key paragraphs from Mandiba so you can rely upon them. And notice paragraph 34, it's not just desiring a state of affairs, it's got to be something compelling. Also in 35 and 36, he refers to the case of T, which we're going to come to now in a moment, and the relevance of the best interest in entry clearance cases. Paragraph 37 sets out that test that we've gone through in the head note. So family considerations, looking at an evaluation of the child's welfare, including emotional needs, then what the other considerations are, and again, neglect and abuse, unmet needs, stable arrangements for physical care. And there is that paragraph on the starting point for the best interests of a child, best served by being with both or at least one of their parents. And there's that quote from SG on continuity of residence. I'm not going to go through it, but SG was quoted. So what I thought it was prudent to do is put that in my slide so you can look at it. McDonald's says this, look at the highlighted bit. In entry clearance officer Kingston and Holmes, the test was satisfied with the child was living in poverty and overcrowded conditions. And importantly, her mother, who'd been looking after her, was about to emigrate to Canada and would not be able to take the child with her. So that's a good example. Tribunals also consider death of a carer to be compelling and compassionate. The fact there are worse conditions elsewhere in the country is not relevant. Bad conditions are not made better by the existence of worse ones. But if you're arguing overcrowding, and often, say, the sponsor will say, in my example, say the maternal aunt has got 6 of her own kids, and with the applicant, it's a 7th. You've got to show that overcrowding must be unavoidable. But you don't have to show intolerable conditions. That's not the requirement. Voluntary abandonment may make circumstances compelling. So there's some really helpful stuff in that extract from McDonald's. You'll be able to use that in your skeleton arguments, your representations, and that might guide your preparation of showing compelling circumstances. Just finally then, last 5 minutes, what about Article 8 and best interest? We've already hinted where we're going with this. But I put a quote from Free Movement, which I think is helpful. You know, too often immigration cases for and about children are devoid of real evidence from or concerning the child. That's why it's great to see the social workers on the webinar saying they'll conduct an assessment. And that's where you perhaps can get the voice of the child here, and they can be talked about. What do you think about going to live with mum and dad in the United Kingdom? The sole responsibility, look at the second paragraph, the sole responsibility test in particular is a distraction from what should, if a genuinely child-centered approach were followed, be the real relevant considerations. It diverts entry clearance officers, immigration lawyers and judges from looking at the situation of the child and causes focus on the situation of the parent. It is almost as if being reunited with one's child is a reward for taking a long-distance interest in their upbringing. The right approach is surely to examine the case from the child's perspective. It is the child's appeal after all, and consider what is best for the child. So certainly, yes, we've got to argue within the rules and say the sole responsibility rule is very focused on that sponsoring parent. But in Article 8, let's make sure we focus on the child themselves. I've put in the notes, the guidance on Gen 3.2 and compelling and compassionate factors. They're there for you. I brought us back to where we start with best interests, Lady Hale in ZH Tanzania, bringing us back to Article 3.1 of the UN Convention of the Rights of the Child and the importance of best interests as a primary consideration. And that case, again, of Mr. Justice Blake when he was president of T. Section 55 applies to children who are in the United Kingdom. It doesn't strictly apply to children outside the United Kingdom. So in our scenario, Section 55 would be relevant to the sponsor's British children, but not to the applicant herself. But the spirit must be considered, and the guidance says that. So Article 8, entry clearance, the best interests of a child is still a primary consideration. And Mr. Justice Blake, in this case, said there is obviously family life enjoyed between T and C as mother and teenage daughter. The question is whether the notion of respect for family life requires her admission under Article 8. In making any such assessment, T's best interests are a primary consideration, so worth lifting that out. These duties can be directly enforced by tribunal judges in determining appeals. And here is that statutory guidance in terms of Section 55. It's the Every Child Matters Guidance 2.34. However, even though Section 55 doesn't apply, however, UK border agency staff working overseas must adhere to the spirit of the duty and make inquiries whether they have reason to suspect that a child may be in need of protection or safeguarding or presents welfare needs that require attention. I've set out Zumbas. I'm not going to go through that, but that's the key sort of factors, often in in-country cases, but I think you can draw some of this for entry clearance cases. And it's important to have a clear idea, look at 10.5, of the child's circumstances. And there's got to be a careful examination of the circumstances of the child. And Mr. Justice Blake hinted at this in T. I've cited the case of Mustafa. Mustafa's a visit visa, Article 8 appeal between husband and wife. But look at the highlighted bit. It was a presidential panel, and it is our view that the decision in Shamin Box, you'll probably find it as on Bailey as SB Dhaka from 2002, is to be followed, and that the obligation imposed by Article 8 is to promote the family life of those affected by the decision. So it's that positive obligation. And sometimes you see entry clearance refusing, saying, oh, it doesn't affect the status quo. Well, we're not about sort of 80s rock bands and status quo. We're about promoting the positive obligation in terms of family life. And a helpful case is the case of Takubo Tekle. It was cited by the Supreme Court in Quila, which was the marriage age case. A mother, father, and their 3 sons were of Eritrean ethnicity, but lived in the Netherlands and had acquired Dutch citizenship. When leaving Eritrea in 1989, the mother had left behind a daughter, then aged 8. When she was 15, an application was made for her to be allowed to enter the Netherlands in order to live with the family, but it was refused. The court held that by the refusal, the state had violated the rights under Article 8 of all 6 of its members. The court observed at paragraph 41 and paragraph 42 that the asserted obligation of the state was positive, the boundaries between the state's positive and negative obligations under this provision do not lend themselves to precise definition, and that the applicable principles are nonetheless similar. The majority view in Gull had become that of the majority. The court did not tarry to consider interference. It moved straight to justification. So they accepted Article 8 was engaged and interfered with, and the question was one of proportionality. Just a final case, because we're nearly hitting 2 o'clock. SD was somebody who couldn't meet the financial requirements as a spouse, but she had with her in Sri Lanka a British child. That British child also had a Sri Lankan passport. They were arguing Article 8 and the welfare of the child. SD has some helpful stuff. Look, British citizenship is a relevant factor. Opportunity to live in the UK, free education, rights to health and welfare provision. But notice there's no equivalent provision in entry clearance to 117B6. And sometimes in representations, I see in entry clearance cases 117B6 cited. That shouldn't be there. But in this case, they didn't give much weight to the British citizenship, particularly because the child had a Sri Lankan passport. So they were able to access the rights and benefits in Sri Lanka. So a bit of a negative case. I think if the child only had a British passport, it would be a different scenario. But they do helpfully point out in that case, and I've highlighted it, because this was an Appendix FM case, that the best interest must be considered because Gen 3.3 applies. Now it's 2 o'clock on the dot. I finished. The QR code is back up to get your free access to my free seminars, all my resources. I put links to LinkedIn, YouTube, Twitter, the Telegram channel, so that's it. Let me just, I appreciate people might have to leave. Somebody said, is the guidance from 2009? Quickly, for 2-3 minutes, going to go through the questions, then we are done, and I'll hand back to Lucy. If you've got to log off, just do fill in the feedback, please, please, please. That's really helpful, and you'll get the stuff tomorrow. Lucy will be back on in a second. Yeah, you can still refer to the guidance in terms of the old guidance in terms of sole responsibility. I had put the new guidance in terms of FM. That's the most recent guidance. Yeah, you can make an application for a child to accompany a partner when coming to United Kingdom. Again, where parents have divorced, again, it's that factual situation and trying to show one has sole responsibility. If you can't demonstrate sole responsibility, could you show serious and compelling? And is there an Article 8 consideration? Does imprisonment mean that a parent automatically has their parental responsibility removed or restricted? I would have thought, say the parent abroad was imprisoned, that would certainly one of those circumstances where all of a sudden the parent in the UK may become solely responsible. Does sole responsibility necessarily the same who may have legal custody? I think we've answered that certainly. And somebody's asked about minimum time. Again, we've talked about that with the case law. Is the 18th birthday a guillotine for the child's best interest? Let me answer that as the final question, because I think that's helpful. Can somebody else talks about adoption? You can rely on adoption and de facto adoption. De facto adoption, you're going to have the issue with the residence issue. In terms of 18, if you're 17 at the application, they'll consider the entry clearance. In terms of best interest, and say, often when I get to court, the child has turned 18. We can't rely on best interest in terms of Article 8, even though the child was 17 at the date of application, and they'll consider the child rules. But in Article 8 case law, there's no bright line at 18. And certainly I've argued this recently in family reunion cases where there's an adult child stuck abroad. You know, a child may still be a child of the family, say an unmarried daughter, she's in her early 20s, but she's still very much not independent, and there's still family life. So even though strictly there's not that obligation with best interests, they're still part of the family, and they're still very much of the child of the sponsor, and the sponsor is responsible for them. I apologise, I've gone 3 minutes over, but I wanted to give some of the questions a bit of addressing and hopefully add some extra value at the end. Lucy, do you want to close things out? Thank you so much, guys, from my perspective for listening today. Real pleasure to have you here. Always a privilege to present these. Lucy, if you're there, do you want to close us out?
Brilliant. Thank you so much today, Adam. That was really, really interesting. Thank you for answering some of those questions at the end as well. And thank you everyone for joining us and for participating in the chat and the Q&A as well. As a quick reminder, the slides and the recording of the webinar will be available to you all tomorrow. And this afternoon, you should receive an email asking to rate us out of 5 stars. So if you have enjoyed, please do leave some feedback. It's very useful to us. And any suggestions for future topics are also very welcome. Our series of webinars continues on the 7th of August with a webinar on film and media contracting, cast, crew and important clauses with Haresh Sood from Clark's Room. Thank you very much, Adam, again, and thank you everyone for joining us. Take care.
Bye-bye. Thanks, everyone.